Before we start the program, I'd like to give you some housekeeping information. First, we encourage attendees to use the computer audio feature of this webinar. During the program, should you experience any audio interference such as static, intermittent audio due to busy network, you can use the optional phone connection, which is indicated on your screen below the webinar slide player. When using the phone for audio, mute the computer audio by clicking the speaker icon in the bottom left corner of the webinar slide player. Do not exit the webinar as your online attendance is being timed, and disconnecting from the webinar before the end of the program will prevent you from receiving your CLE credit. Second, we will have a live Q&A session during the last 20 minutes of the program. You may submit questions anytime during the program using the Q&A function in the webinar interface. After the program, you can use the post-program question form to send program-related questions to the program's faculty. The post-program question form can be accessed from the program attendee page. Use the link provided in the confirmation email you received for this program to get there. Third, if you're seeking CLE credit, you must attend the entire program. Partial credit is not available. The ABA now uses an alert system for attendance verification. You are required to respond to verification alerts throughout the program to verify your attendance. Immediately after the program ends, a link to the program evaluation will appear on screen. Please take the evaluation to access the attendance confirmation and request for CLE credit. Some states also require that we collect your bar license number on the attendance form. Once the completed form is submitted and your attendance is verified, your certificate or certificates will be emailed to you. Do you have an idea for an ABA program? We'd like to hear it. Enter the HTTP and then ambar.org/topic suggestion and fill out the simple form. Final reminder, this program is being recorded. To purchase a recording of this webinar or any other ABA program, visit the ABA web store at shopaba.org or call the ABA at 800-285-2221. Welcome to the COVID-19 Legal Strategies for Nonprofit Meetings, sponsored by ABA CLE. We are joined on this program today by Jeffrey S. Tenenbaum. Jeffrey is one of the nation's leading nonprofit attorneys and also is an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C.-based Tenenbaum Law Group, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award and is one of the only 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, and currently serves as chair of the American Bar Association's Trade and Professional Association Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. Jeffrey, please proceed with today's program.
Sorry, good afternoon, everyone. My apologies. My phone was on mute. Let me get started. Welcome to our program today entitled COVID-19 Legal Strategies for Nonprofit Meetings. My name is Jeff Tenenbaum. I'm going to be focused today on the impact of these incredibly difficult last few weeks that we've been experiencing on one sector of our nation and our economy, and that is the meeting sector, and the impact of COVID-19 on the ability of associations and nonprofits and other event organizers to hold and conduct their upcoming meetings and conferences, especially those that are scheduled for the next few months. As you might imagine, as you all know firsthand, this virus, this outbreak has had a dramatic effect on everyone's everyday lives. But in addition, it's also had an impact on those who organize meetings and conferences. And the events of the last few weeks and the last week or two in particular have just thrown a massive monkey wrench into the planning and operations of so many event organizers and their ability to hold upcoming meetings and conferences. In their quest to figure out how to grapple with this, how to cancel, postpone, reschedule various meetings and conferences, there are some incredibly difficult legal issues that have come into play, particularly with respect to the contracts that these organizations have entered into with all sorts of event venues. Primarily, we're talking about hotels and convention centers, but certainly plenty of other event venues as well. And other meeting vendors, particularly larger conferences, typically have a lot of contractual relationships with other meeting vendors as well. And the inability, the impossibility, the inadvisability, the impracticability of holding these meetings has very significant impacts on the contracts that these organizations have entered into with these various meeting venues and others. And today's program is going to focus on, so what is the impact on these contracts? What is the ability of an association or a nonprofit or any event organizer that has a conference or meeting scheduled for a week from now, 2 weeks from now, 4 weeks from now, 8 weeks from now, and some of those latter ones are actually posing some of the greatest difficulty. What is their ability to excuse performance under the contract, to postpone performance under the contract, to avoid cancellation penalties and or attrition penalties that might otherwise be assessed against them by the hotels or convention centers or others? That's what today's program is going to focus on. Sorry, Wendy, my system does not seem to be allowing me to advance the slide. If you could advance to the next slide, that would be great. Okay, this is the agenda for today's program. So as I said, we're going to focus principally on the impact of COVID-19 on nonprofit and other meetings and events, with a specific focus on meeting contracts and event cancellation insurance. I'm going to talk a little bit about the difference between contract law provisions and common law principles. I'm going to do a heavy focus on force majeure contract provisions, and I'll explain what that means shortly. I'm going to talk about options that event organizers have to attempt to cancel without penalty or reduce penalties. Also, I'll talk about the pros and cons of canceling now or waiting to cancel or waiting to attempt to postpone your meeting or event. If you do proceed with rescheduling the meeting for several months from now, what steps can you take to reduce attendee risk and risk to the event sponsor then, meaning when you hold the meeting? And then finally, I'm going to focus on a little bit on event cancellation insurance, commercial general liability insurance, and workers' compensation insurance, all in an effort to reduce the liability risk of the meeting sponsor. And finally, and we're doing this already, working with quite a number of clients on negotiating future meeting contracts. This is all having very significant implications in that regard. Next slide, please. So, force majeure. What does this mean? You're all lawyers on the line. Some of you may do a lot of work with contracts, some of you may not. I'm sure, though, at some point in your careers, like me, I've seen probably thousands and thousands of force majeure clauses. What the term means is overpowering or irresistible force. And it basically means it's a legal excuse to avoid performance under the contract without penalty. And it can apply to one party or the other, most certainly. In fact, these days it's actually applying typically to both parties in two-party contracts with respect to event contracts. But there's a difference between common law force majeure principles and force majeure provisions in meeting contracts. It's the latter, the provisions in the meeting contracts, that have been kind of front and center in all of the negotiations in this crisis But it's the former that can be helpful if a contract lacks a force majeure provision. Sometimes these are called impossibility. Sometimes they're referred to as termination for cause. Pretty much it's going to be referred to as one of those three things, but it's all the same thing. And this concept of if this overpowering or irresistible force applies, if a force majeure event occurs and it otherwise meets the standard in the contract for that provision, then either or both parties are excused from all performances and, for instance, any cancellation penalties. Most hotel and convention center contracts have significant cancellation penalties if you cancel without an excuse, terminate without cause, if you look at it that way. And those cancellation penalties typically get greater the closer you get to the event. Generally, when you're getting, 3 months, 6 months, 9 months out from the event, sometimes even more, the penalties are essentially 100% of the profits that the hotel or convention center would have earned. So these are very significant cancellation penalties. I work with probably about 150 now different associations and nonprofits, working with probably well over 100 in the last 2 weeks alone on all of these issues involving meeting contracts and upcoming events and the effects of the virus. And I can tell you that these provisions are all over the place, although there are certain kind of common themes that we see and certain common language that we see through most of them, and I'll talk about those details. The details are critical, as you can see in the second bullet point, because not all of these clauses are the same. Some are very different. The devil is very much in the details. In fact, just this morning, my colleague and I were on the phone with a client who was telling us that the hotel that we're helping them negotiate to try to get out of their meeting and hopefully reschedule it for the fall, they had initially thought that the force majeure provision in their contract was the same as most of their other organizations that have meetings. And when they realized yesterday that it was a different provision, a provision that's actually much more favorable to my client, to the association, they said, oh, wait a second, we now need to run this by our lawyers because our position may be different. They had initially denied a force majeure cancellation. They had denied the ability of the association to cancel without penalty. Now they're taking another look at it because they realized this particular provision was different than the other ones. So as I said, a successful force majeure cancellation will allow you to cancel the event without any penalty to the venue, but you can expect strong pushback right now from the hotels and convention centers whenever you're canceling based on a force majeure provision, even if your position is strong. We've had, over the last few weeks, some of the strongest force majeure provisions I've ever seen, some of which I helped to negotiate, and the hotels and convention centers have still been pushing back. There's been very, very few cases that I've been involved in, at least, extremely few. I think you can count them on one hand, where the hotel has, or the convention center says, you're right, we're going to accept your force majeure provision. That is just now starting to change because of some of these bans on large gatherings that are being imposed by certain states and cities, and we'll talk about that in a minute. Historically, these provisions have probably been some of the least negotiated in every hotel and convention center contract. And I can tell you that from a lot of personal experience, a lot of folks just don't pay attention to it. They don't think much of it. They think they're all the same. Well, that will never be the case again going forward. This is the one provision that has been the center of every contract negotiation and analysis that I've been involved in since this crisis began. And then finally, it's an important concept to understand that generally speaking, if a force majeure clause applies, it will excuse complete performance under the agreement. And that's the way that almost all of these are written. But as I'm going to talk about in a little bit, there is a way to write a force majeure provision to also excuse partial performance as opposed to complete performance. And I'll talk about that in a bit. Next slide, please. Okay, so if, and a lot of our clients are, say, associations that have their annual conference in a given city. They take over some or all of the convention center, and then they have multiple hotels, 8, 10, 12, 15, 20 different hotels. Every single one of those hotels and convention centers are likely going to have different contracts. Sometimes they're negotiated by the Convention and Visitors Bureau of that particular city, and there will be some standardization of the contracts, but generally each hotel, each brand is going to have their own standard form contract that they're going to work from. Each one is likely separately negotiated. Sometimes there's, again, a joint negotiation through the CVB, but you have to look at every single provision differently. We have one recently that we were helping to negotiate. It was a conference in Austin. This is before Austin kind of shut the city down, and it's been pretty much, like a lot of people have referred to in this industry, a game of chicken that's going on between the event organizers, the associations, and the hotels and convention center, kind of seeing who's going to blink first. And as we were, going back and forth in that game of chicken, we were analyzing each and every hotel force majeure provision separately, and they were all a bit different. We had very strong positions with some weaker positions in others. Same thing for the convention center clause and the force majeure clause there. And in the end, Austin banned all gatherings of over, I forget the number, if it was 50 or 250 people, but either way, it clearly applied to this organization. And then the convention center and everyone said, okay, we're canceled. You don't owe us anything. But until that point, it was very much a different story. So this is really important concept. The force majeure analysis has to focus both on the language of the provision itself, which is fixed, that obviously can't be changed. I mean, the parties could agree to amend it, but they never do. So that part is fixed. But the facts on the ground and how that provision applies to the facts on the ground changes literally these days. Every single day, things have been changing, city by city, state by state, federally, and then with respect to each particular situation with each hotel, and also the dates of when the meeting occurs. So for instance, in DC, where I'm based, there is a ban on gatherings of over 250 people. Right now, it was an emergency regulation that the mayor signed into force that lasts through March 31st. In the order, it says that if there's a state of emergency that continues to be in place, she reserves the right to extend it. But right now, that only extends through March 31st. So if you have a conference coming up in DC scheduled for mid-April, and I happen to have an association client that does, right now technically that ban does not apply. And technically, if the hotel and or convention center wants to play hardball, which most of them are, unfortunately, technically that ban does not apply to their meeting. Will it likely be extended? I think we could all say likely yes. But unless and until that happens, right now, it is not illegal or impossible to hold a conference in DC. Now, we're going to get into some other factors, such as if the vast majority of your attendees are prohibited by their own employers from traveling, and if there's a ban on them traveling, doesn't that also make it impossible for you to hold a meeting? I would certainly argue yes. You can also look at things like if the president yesterday issued a strong recommendation for there to be no gatherings of any individuals over 10 people. The CDC the day before had said, we strongly encourage no gatherings over 50 people, and I believe they're going to be modifying their guidance down to 10 people. But those are recommendations. They're not mandates or bans. And the Trump administration to date has decided to leave the bans up to the cities and the city states and the counties to decide those things. So it's very much city by city, county by county, state by state analysis in terms of mandates or bans on certain mass gatherings of a certain size. Even the question of how big is the meeting. If there's a ban, like a lot of states and cities have on gatherings of 250 people or more, if historically you've had around 250 attendees, say last year you had 250 attendees, but you don't always have 250 room nights. Even if, say, it's at a hotel, for something that size, it's going to be at a hotel, usually not a convention center. So it's at a hotel, you have sleeping rooms, but not everyone stays in the sleeping rooms. Some people would like to find less expensive hotels online, some stay at Airbnbs, some might drive. And so the total number of attendees does not necessarily equal the total number of room nights. That's been a point of contention as well. When I tell you that hotels and convention centers are pushing back extremely hard, they certainly are. I mean, I certainly understand the massive amounts of potential revenue that they have at stake, and I'm certainly sympathetic to that. But as my clients are on the other side of that aisle, it's not been a pleasant experience in most cases. I shouldn't say all. And then finally, this last point in this slide, if you can, and this is more kind of a suggestion going forward for future meeting contracts, try to tie the force majeure provision into your attrition provision. So an attrition provision is different than a cancellation provision, cancellation penalties like I already talked about. Attrition is you hold your meeting, and with attrition, it's a concept of you're going to have a minimum number of sleeping rooms, essentially like a guarantee, and a minimum amount of food and beverage that you agree to purchase, again, like a guarantee. And usually you have a right to reduce those numbers if you want, reduce or increase, usually reduce, obviously, at certain points of time out from the meeting. And then once you get closer to the meeting after a certain point in time, 6 months, a year, 3 months, whatever it is, you're not allowed to reduce those numbers anymore. And if your actual numbers end up coming in less than that for the sleeping rooms and or for the food and beverage, then generally you're going to be hit with penalties because essentially you have to meet the guarantee that you had given to the hotel. But what's going on now is a lot of associations and other event organizers that have meetings that are scheduled for March, April, May, even June, are recognizing they're not going to be able to have these meetings. They may well be banned legally from having them. Even if they can, it's not likely that most people are going to be willing or interested to get on a plane or go to a large gathering, even in May or June of this year. And so they're trying to push them back. But right now, we even heard the president say yesterday that this curve of the virus might not flatten until sometime in July or August. And if that's the case, we know there's still going to be a lot of lingering fear and concern from folks and potential attendees to travel. So we have to assume that even if a meeting is able to go forward, say in August, that it's likely going to have less attendees than the number that were expected and budgeted for before the virus broke out. And so as a result, you want to be able to protect yourself. So either A, hopefully you can just maybe negotiate the attrition penalties away, which some of our clients have been able to do, or you can reduce those guarantees down to a very low number, which would be great, or you can tie it into the force majeure clause so that if the force majeure clause applies, but you decide to go ahead anyway with your event, then at least you won't be penalized. Your attrition penalties maybe could be waived or at least reduced. So these are all kind of negotiating strategies for your future contracts. Next slide. Okay, so this is what I would consider pretty much a model force majeure contract provision from, of course, the perspective of the association or nonprofit that's holding the meeting. And the way that I've been describing these force majeure provisions, it's kind of hard to see with all this text on the screen, but it's essentially, I view it as kind of a two-part test. And both parts have to be satisfied in order for the force majeure clause to apply, and therefore for either of the parties to get out without any penalties. And by the way, when I say get out without penalty, that also means that if the force majeure clause does apply and you have given deposits, like many associations and others have to do in connection with a meeting, then you are legally entitled to get your deposit back. Now, of course, if you exercise your force majeure option, the hotel or convention center does not agree, and they say, hell no, we don't agree with you, here's why, and we're not giving you your deposit back, we're keeping your deposit, and here's a bill for the rest of what you owe. And by the way, when they disagree with you, they will generally send you a bill the next day for everything that they believe that you owe them. And so that, well, I'll get to that issue a little bit later about deposits. But that two-part test that I'm talking about is, first is, do you have a qualifying force majeure event? Is there an event that is triggered by this provision? So as you can see here, every force majeure provision, almost everyone I've ever seen, always starts out with acts of God. A lot of them have war, government regulation, which is obviously very relevant here, disasters, fires, and you see I highlighted the word disease. That is actually not that common in a lot of force majeure provisions. It should be common. It's something you certainly want to try to include going forward, but it's actually not that common. And there's a bunch of other things. Terrorism, threats of terrorism often is not included. It's something I started including after 9/11. Curtailment of transportation facilities, preventing or delaying 25% of the folks from attending. Something like that is fairly common, but generally that refers to like shutdowns of airlines, some of which we're seeing now, potentially trains and other forms of public transportation. But then look at this other part, or other similar cause beyond the control of the parties. That's absolutely key, to have some catch-all phrase like that in there, so that even if you're some unforeseen event that we can't imagine happens, at least if it's a similar cause beyond the control of the parties, and seen other language similar to that, that will trigger the first part of the test, which is really important. Then the second part of the test is, what effect does that triggering event have on the ability of your organization to fulfill its obligations under the contract? I'd say 80% at least, maybe 85% of all of the force majeure provisions that I reviewed in the last 2-3 weeks say making it illegal or impossible to hold the event. That's all they say, illegal or impossible. And that's where so much of the battles that we're having with the hotels and convention centers are coming from, as to, is it truly illegal or impossible right now? Or, as this provision points out, inadvisable or commercially impractical. Even if you just had the inadvisable language, and I've heard earlier in this webinar to that conversation I had with a client this morning, in their contract, their force majeure provision had that word inadvisable. And that's when the hotel's attorney said, oh, wait, this is different from all of our other provisions. We have to take a closer look at this. And that's because it's a much broader provision, much easier to cancel when it's an inadvisability standard as opposed to just illegal or impossible. And I really like the commercially impractical as well. In the current circumstances, it's almost laughable to find a situation that it's almost impossible to find a situation where an inadvisable or commercially impractical standard would not excuse performance under the agreement in these circumstances. And then finally, it says, if this occurs, it can be terminated without penalty and with performance fully excused, with written notice from one party to the other. That's very common. And then I added at the end a sentence about kind of tying it into the attrition penalty. So if you decide to go ahead anyway, at least you won't be hit with the attrition penalties. Next slide, please. Okay, pretty much these are things that I've already said. The hotels, convention centers, when you're negotiating these provisions, they're almost always going to push for just the impossible or illegal standard. And they're also going to try to limit that list, the kind of part one of the test, to a very narrowly defined, very specific list, and avoiding any kind of catch-all phrases. I'd say that latter part is generally easier to negotiate, to get some kind of catch-all phrase. The getting it to be broader than just impossible or illegal tends to be more difficult. And as I told you, I prefer adding commercial impracticability and advisability, and be sure to include some or similar cause, any similar cause catch-all type phrase. Next slide, please. This is a bit repetitive. I've already said what I said in the first bullet point. The language matters, devil's in the details. But the second point is something I have not yet talked about, and it's an important concept. If you remember at the beginning, I talked about the difference between force majeure contract provisions and force majeure as a common law doctrine. Force majeure does exist as a common law doctrine. I think most attorneys, contract attorneys, meeting contract attorneys, generally believe that if you have a force majeure contract, a force majeure provision in your contract, then the parties have bargained for it to be written that way. You're not going to be able to look beyond that to some kind of force majeure common law principles. You've essentially overridden the common law principle by putting it into your contract. But there's a separate common law principle. It's obviously related, but it's separate, called frustration of purpose. Every time one of these crises happens, nothing's ever been as bad as this crisis, but everything from 9/11 to SARS to MERS to Ebola to other crises that have affected meeting contracts in the past, we always kind of do a deeper dive into this frustration of purpose doctrine. And it's something that does apply. I've yet to see a hotel or convention center, agree to it as an ability, as a way for letting an association out of their meeting contract. But theoretically, it does apply in that if the principal purpose of the contract is unable to be satisfied, it's just completely unable to be satisfied, your purpose has been frustrated, and you should be excused from performance. But what the case law says in this area is that in order for this kind of relatively narrow doctrine to apply, the purpose of the meeting has to be expressly spelled out in the contract itself. And that's not generally going to be the case. That being said, it is a viable argument, theoretically at least, and in all of the cancellation notices that we've been helping our clients to draft to send to hotels and convention centers, we have included that in the long laundry list of why our clients should be excused from performance. Next slide, please. Okay, I'm sorry. Like all of you, I'm a lawyer. Some of you are better at, a lot of you are probably better at PowerPoints than I am. I tend to make them a little bit too dense. And I was working on this late last night, trying to update it for all of the kind of recent developments and trends and where things tend to be going, and I probably went a little bit overboard with too much text here. But this is critical. So I've kind of given you all the background, explained the principles. Now, we're getting into what is keeping my colleague and I extremely busy every day for about 16 hours a day for the last at least week and a half since the crisis kind of kicked into another mode. And that is helping my clients, you're helping your clients, figure out, okay, here's the situation today. Here's our contract or contracts. Here's the situation on the ground in this city at this time. Here's what the feds are saying, CDC, White House. Here's what the governor has said. Here's what the mayor has said. I had one yesterday where the event was going to be at the Gaylord property, which is in Grapevine, Texas. Dallas, the city of Dallas, Texas, and Dallas County had a particular ban in place, but we quickly determined that Grapevine, Texas, where the Gaylord, it's like a smaller convention center, is not within the confines of Dallas County. It's in Tarrant County, and they have a different set of rules on prohibitions on mass gatherings right now. So where the event is held and what the governmental jurisdiction is matters, when it is going to occur, how many people it is expected to have, particularly what you could show that attended last year, and also looking at how many registrants you had so far for this year if it's coming up soon. All of those things factor into your analysis. So I have here, you got to look at World Health Organization and Centers for Disease Control and Prevention declarations, government bans, or admonitions against large gatherings, government and or private travel bans on your attendees. We have a lot of clients whose attendees at different conferences, like in some, they come from the university setting. Universities and colleges almost across the board, particularly the larger ones, have for a while now, the last couple of weeks, have put really strict travel bans, either literal travel bans or effectively travel bans, making them jump through a million hoops if they travel somewhere, on their employees, particularly professors and whatnot, from traveling, and has a very real effect on, even if your force majeure clause just has the impossible or illegal standard. Because frankly, if it has the inadvisability or commercial impracticability standard, you should be able to get out already, no matter all of these other things. So this focus is really on, those 85% of the contracts that have the illegal or impossible standard. So you have to be able to make the argument that it's illegal or impossible. Most of the hotel lawyers and the chains themselves are telling their hotels and their lawyers, look, unless it is absolutely legally prohibited for this organization to have the meeting, we are not letting them out under a force majeure provision. I did see an email from one today from a client that it said, in light of the CDC's recommendations about no gatherings of more than 50 people, they actually were going to excuse performance. But that's highly unusual. That's not been the norm whatsoever, because it's not a ban, and that's a very deliberate step, by the way. I don't think the CDC has the ability to issue a ban, but the White House certainly does, based on the CDC's recommendations. They have deliberately not done that. The administration is deferring to the states and localities, I believe, because the president has said that the virus is affecting different geographic areas differently, and they don't feel like a blanket mandate would make sense at this time, but they're certainly keeping it in reserve as a possibility. So for now, it's making the analysis a lot more challenging. If you have event cancellation insurance, and I'm going to talk about that in a little bit later, and if you believe it will apply, that can make a big difference in your decision to terminate. In some cases, particularly where you have the employer-imposed travel ban issue, we've been encouraging our clients to gather evidence from their attendees and their employers to say how many of them actually have travel bans that have been instituted that prohibit them from traveling for a certain period of time, that would make it impossible for the vast majority of the attendees to attend. I believe that would create a very strong argument for impossibility under the force majeure clause. But if it gets to that point, the hotel, especially if it gets to arbitration or litigation later, and even perhaps before that, the hotel is likely going to demand evidence. So it's not just taking the association's word for it, but they're going to want evidence that truly these folks weren't able to attend. So doing some kind of survey or polling of your attendees can be very helpful in that regard. Even if you lack a strong legal position on the force majeure side of things, in the past, when these situations happen, we would go to the hotel or convention center, Sometimes reach out to like the corporate. I mean, now there's been so much consolidation in the hotel industry. You can still do this, but it doesn't work nearly the way it used to be. You used to reach out, to the head of like the large, corporate and associations group, at a particular hotel chain. They have folks that were dedicated to this. They would reach in, help to kind of mediate the situation. And almost always you could rebook your meeting for some future date. If it's your annual meeting and you already have the next 2 or 3 booked, you book it 4 years out, and the hotel would waive the cancellation penalties. Well, they're not being nearly that flexible these days. We had one yesterday that said, if you rebook your same meeting within 12 months and book 2 additional comparably sized meetings, then we will let you out of your cancellation penalties. They're being much more difficult. Some are being a little more lenient. I think every day that goes on, we're seeing a little more leniency and flexibility. I think because a lot of these hotels recognize that it's likely going to be increasing. It's going to be increasingly common that the associations and nonprofits will be able to exercise the force majeure rights, because there's going to be more and more bans on these mass gatherings, and then they're not going to have anything. So they'd rather get some meeting rescheduled than get nothing. But to date, including as recently as yesterday and today, we're still seeing a very, very hard line across the board. And then on the part of the hotels and convention centers. And then the last consideration, which I mentioned here, is who has the money, right? In most situations, there's either no deposit paid by the association, or there's a deposit paid, but it's not a massive amount, percentage-wise. We do have some, though, that have paid some very significant deposits. I had one where the kind of the balance of the deposit, which was the bulk of the money, was due, and it was a smaller association. The treasurer had actually put the check in the mailbox, and then started reading about this. I think you might have heard another webinar I did, and he literally ran to the mailbox and pulled it out before it went, and now we're negotiating with the property. If the property has a sizable deposit already and they disagree with your position, they're going to keep it, and then you have to pursue them if you want to get it back. On the other hand, if you haven't paid anything yet, or only a very small amount, they're likely going to keep your small deposit, but then they would have to pursue your organization for the funds that they believe that you owe them. Now, I am not at all suggesting that they're not going to pursue you. Even if they don't file a lawsuit against you, they could send it to collections. It could do great harm to your corporate credit rating. They could send it to a collection agency, which could then sue you. I mean, there's a lot of adverse effects that can come from that. And I'm not suggesting that if they don't have the money, just forget about it and you're golden. But it does affect the negotiating posture and leverage of each side. Next slide, please. Okay, pros and cons of canceling now, or waiting to cancel, or waiting to attempt to postpone. This is, again, this is where the rubber meets the road, and this is where a lot of the more difficult negotiations are going on right now. And this is where kind of that game of chicken comes in. We had some clients that a week and a half ago were panicked, and it's not, I don't blame the organizations and the staff at all. If they're getting a lot of pressure from the members, from the attendees, from membership associations or whatnot, and they're saying, look, are you reading the news? Do you see what's going on? We need to know, we need the game plan, our meetings in mid-April or end of April or beginning of May, and, we just want to know that it's canceled, or let us know, even before it was clear that everything was going to be canceled for the foreseeable future. There was a lot of open questions. So they were under enormous pressure. And our advice to most of them was, unless your meeting is coming up next week or the week after, and we did have a number of those, and those were tougher. But if it's coming up a little bit later, wait. Just wait. Be patient. Blame it on your lawyers. And sure enough, in at least half those cases now, I just saw another one come through during this webinar, the cities in particular have enacted bans that now apply to them, or they enacted bans and they've now extended the time period so it applies to their meeting. And now they're able to get out with a force majeure clause and not have to pay anything. So waiting to pull the cancellation trigger matters, because the way the hotels and convention centers look at this, what matters is not, what happens is, what are the facts that exist at the time you pull the trigger and send that written cancellation notice? Not before and not after. It could be the next day, the state or the city imposes a ban on any gatherings of 50 or more. But if that didn't exist the day that you pulled the trigger, that's not going to be relevant to the analysis. Now, I would still argue, and I have been in some of these disputes, that it's still relevant to the calculation of the cancellation penalties. And while we still have arguments why the force majeure provision could apply, but I would say even assuming arguendo that the force majeure clause does not apply, then we go next to damages. And if this has actually happened in a few cases, the association gave notice before the ban came into place. The next day the ban comes into place, effective immediately or effective as midnight that day, like most of them are, which would mean even if the organization went ahead with a meeting, they would have had to shut it down and send everyone home the next day. And so we had two cases where literally 4/5 of the meeting, roughly, would not have been able to occur. They would not have been able to get that sleeping room revenue. Again, depends on cancellation policies for individual attendees and whatnot. Certainly wouldn't have had the food and beverage revenue. And so I would argue that in calculating the cancellation damages, that there should be some prorated split, and the vast majority of the damages should not be applied in those situations. But that aside, you want to have the most favorable facts exist at the time that you pull the trigger on the cancellation notice. Waiting can sometimes significantly strengthen your argument. The same goes for the event cancellation insurance analysis, which I'll talk about in a few minutes. Really right now, there certainly may be at some point a federal ban on mass gatherings. Right now it's just recommendations and guidance, like I already talked about. The states and cities and counties are where it's at. Some, obviously, if a hotel or convention center shuts down on its own, that's certainly one thing. And if that shutdown applies for your dates, that's certainly relevant. But right now, even voluntary shutdowns are generally not being done with any date certain of when that's going to end or not end or whatnot. And so it doesn't give you a lot of certainty if your meeting is 2 months from now. Same thing with travel bans. I mean, we have not seen any domestic travel bans imposed by this administration. We certainly could, and there have been hints that that could occur, particularly with respect to some of the hot spots of the virus in this country. Right now, that has not occurred. We did have some where there were, travel bans, like initially for folks coming from China. Now that's extended to Europe and UK and Ireland. In those situations, if you had a significant number of attendees coming from those jurisdictions, which some did, that's certainly relevant, or even ones that have meetings that are to be held over in some of those countries, that can have a huge impact. But my point is, all of these considerations have to be taken into account. It's a very difficult analysis. There's a lot of different moving parts, and it's changing on a daily basis. Next slide, please. And one more point here, come up a lot recently, the concept of postponement. So generally, if you go to a property, a hotel, and you say, we want to postpone our event, that's going to be treated by the hotel the same as cancellation, unless there's some right in the contract to postpone, which frankly I've never seen. Maybe exists somewhere, but I've never seen one. But if there is no unilateral right of one party to postpone, then a postponement equals cancellation. So postponement only comes into play if we're essentially talking about an amendment to the agreement, where both parties agree we are going to amend the obligations of each party jointly. So we're going to agree that whatever's in this agreement, the dates, the cancellation penalties, it's all going to be null and void because we're going to postpone this event for 6 months from now. And we'll either amend the contract or enter into a new contract. If you do that, that's an agreed upon postponement, but that's essentially an amendment or a replacement of the contract with a new one, because both parties agreed to it and they agreed to it in writing. But you need to be careful. As soon as you start, there are ways to talk to a hotel or convention center about a potential cancellation or potential postponement, but you want to be very careful in those discussions. I've been counseling my clients on this from the beginning, to be very guarded in how you talk, to say, we're keeping all of our options open, but you don't want to, say something that inadvertently is taken as a notice of what's the word, like an anticipatory breach. We don't want to get into an anticipatory breach situation. We actually had a client that inadvertently, we were helping them in the event that they had to cancel. They hadn't decided to yet, but in the event they had to cancel, we had helped them, like we're helping most of our clients with their notice to their attendees, explaining that they've decided to cancel. Here's the reasons, here's the protocol for refunds, or rolling it over to the next conference. Here's what you need to do to contact the hotel to cancel your reservation. If you gave a hotel deposit, here's what you need to do to get it back. Contact the airlines, et cetera, et cetera. And they inadvertently, I won't get into the details, but it inadvertently got out there. One of the hotels in the block saw that and immediately sent out cancellation letters, emails to all of the attendees who had registered for that hotel. So they took that as cancellation. Obviously, that was a technical glitch. It wasn't intended. They were able to, in the end, kind of fix it and recover from it, although there was a 24-hour pretty panicked period there. But it just goes to show you need to be very guarded in how you communicate with the properties about these things until you make the final decision of what you want to do. And most of these do require that if you do want to cancel or exercise your force majeure rights, the notice has to be provided in writing to the other party. As of right now, a week ago, a lot of people were thinking about postponing their events until maybe July or August. Right now, I'd say the prevailing winds are telling people that's not even safe, a sure bet, and either push it to later in the year or just cancel this year's event altogether, which is, I'd say, the vast majority seem to be wanting to just, if they can, cancel this year's events instead of just pushing it back to later in the year. Of course, if you don't have a strong force majeure provision and the facts on the ground in terms of governmental bans and whatnot aren't favorable for you right now, and that is the case for a lot of organizations, then you might not have a choice. So, another one we're working with earlier today, they actually have a really strong force majeure provision, and we're recommending that they just cancel, and then they can talk about, potentially rescheduling after, but with a lot more leverage, because then they can just walk away. But they were looking to reschedule, and the only dates that worked for the hotel with its availability was August. I said, look, if they're going to give you a really good deal, for August, and you feel comfortable, I'm okay with that if you have a really favorable force majeure clause. So essentially, if the situation is still unchanged for the most part, not just that there's a ban on mass gatherings or a travel ban in place, but that it's still a pretty bad and unsafe situation with the virus, you want to make sure you have that sort of inadvisability, commercial impracticability, other language there to help protect you, so that come August, if you decide you're in late July and you're like, oh boy, this is not going to work, no one's registering, at least either you can get out without penalty, or your cancellation and or extension penalties get reduced close to zero, something like that, so that if you do decide to move ahead, at least you're not going to be heavily penalized for it. Of course, and we'll be getting to this with clients later, we're not there right now, if you do decide to postpone your meeting and then you move ahead with having that meeting, even say in July or August, there's still going to be risk out there without any question. Unless there's some miraculous vaccine that's developed that quickly and distributed to the whole population by then, which seems highly unlikely. The risk to attendees, the risk to your employees is still going to be there. It's going to be significant. In the beginning, when this crisis first broke, the CDC had guidance that they put out on their website. It may be still there for mass gatherings and what you need to do to be safe. Kind of the usual advice of don't shake hands, sneeze into your elbow, lots of hand sanitizer, wash your hands, wipe down surfaces with this high-powered disinfectant, all that stuff. And that seemed to be, like, if you were doing those things and you had a meeting 2 weeks ago, even if someone contracted the virus at your event, if you were doing all of those things and you have lots of signage all around the venue to warn people about that, you would likely be able to avoid a liability for negligence because you're following the CDC's guidance. Now, 2 weeks later, a whole different ballgame. In fact, if an organization were to hold a meeting now, even if it were technically legally not banned, and there are a number that could be like that, with all of the guidance and strong admonitions and recommendations out there, if someone did contract the virus or got quarantined or suffered other harm at your event, you're going to have a much more difficult time avoiding negligence liability. And kind of that's what the that last bullet point talks about. Next slide, please. Okay, event cancellation insurance. So for those of you that don't do a lot of work in the meetings industry or in the association world, you may not be familiar with this. And you're all familiar with all the basic types of insurance: commercial general liability, property insurance, D&O insurance, E&O insurance, etc., cyber insurance. Event cancellation insurance is something that I've been familiar with for the 25 years I've been practicing law in this space, because it's something that associations in particular typically purchase, or at least consider purchasing for their larger meetings and conferences. And what it says is that if your event is either canceled or postponed, or you have reduced attendance because of a triggering qualifying event, then the cancellation insurance will kick in, and it will essentially make you whole for your losses and make up your lost profits. Not only your loss, and this is important because even in a situation where you're able to, say, cancel your annual meeting without penalty under a force majeure clause, you're still out all of your net profits. And for some larger organizations, that's millions of dollars. For some, or even smaller organizations, that can be, your profits can be 1/3 of your annual budget. These are huge amounts. So even a great case force majeure position doesn't enable you to recover your lost profits. If you do have event cancellation insurance and it applies, though, you can recover your lost profits. So there are 4 leading event cancellation insurance companies in the U.S. They're listed here. I don't need to read through them. As of mid-January of this year, for all new policies that were bound and issued after that time, COVID-19 is now expressly excluded from coverage under those policies. So it is impossible to get coverage for any claims arising from COVID-19 post mid-January of this year. And that will likely be the case for a long time, if not ever, unless there's a vaccine developed at some point. Many events now are uninsured, because a lot of times event organizers, associations, and whatnot will wait until 6 months before the event to buy the coverage. It's a little different than most policies where you're buying it kind of once a year, you pay your premium and it applies for the year. I mean, I guess it's kind of the same that they do it once a year, but for whatever reason, the timing, a lot of them do it like 6 months out. And as a result, a lot were waiting, just at typical beginning of the year, that's when they do their event cancellation. And a number of them, got their policies bound after that new exclusion was instituted. But for those before that, this is a little bit complicated. This is the way kind of insurance works. You sometimes have things that are covered and then they're excluded, but then you can buy back coverage through what's called an endorsement. It's like an amendment. And then sometimes those endorsements contain exclusions as well. Really complicated, but really important. So here, since 2003, the SARS virus broke out. The 2 biggest, I'd say the 2 policies that are bought the most, Showstoppers, which is the one endorsed by the American Society of Association Executives, and Expo Plus, which is offered through Mercer, and the broker for the first one. Those 2 contained an exclusion for communicable diseases, a very broad exclusion that said, if any claim arises because of a communicable disease, has a whole bunch of examples, there's not going to be coverage. But you could buy an endorsement to those policies to buy back that coverage. And it wasn't that expensive. If your premium was maybe $10,000, you could buy the endorsement for $2,000. It's, all varies based on the size of the meeting and how much revenue is at stake. But not break the bank kind of stuff. Unfortunately, a number of our clients were reportedly, is what they tell us, never told that the communicable disease endorsement was an option, particularly on the Showstoppers policy, and they weren't informed by Aon that was an option. That's what they said. I don't know if that's the case or not, but there's a lot of very frustrated associations that wish they would have and would have purchased the coverage. They were just never made aware of it. But that being said, if they did purchase the communicable disease endorsement under those policies, then generally speaking, they will have coverage arising from this crisis for meetings that are covered by that policy. Again, generally, you can buy multi-year policies, by the way. So I've reviewed some that last for several years. So if you had 1 or more meetings that were covered by that policy, then it is, very, very possible that you can have coverage under those policies. Now, one thing to say, though, is talking about something excluded, you buy back the coverage through the endorsement. That endorsement does not have the coronavirus exclusion, and nothing before mid-January this year had a coronavirus exclusion because no one knew about it. That endorsement still says that if the cancellation is due to the fear or threat of attendees. If attendees are just afraid to contract the virus, or the threat of contracting the virus, if that's what's keeping them away, then the coverage will not apply. But if it's literally impossible for them to attend because of a governmental ban or whatnot, then the coverage will apply. So in a lot of cases, I've yet to see, because just hasn't gotten that far yet, I've yet to see a successful claim. We have helped several of our clients file claims with some of these insurance carriers for coverage. And in most of these cases, I'm expecting there should be coverage, and this is huge. This could be break the bank type stuff for a lot of organizations. The HCC policy, Houston Casualty Company, that policy actually even pre this year did not contain a communicable disease exclusion in the core of the policy. I don't know if that was intentional or not, if they were trying to use that as a marketing advantage, competitive advantage, but for whatever good reason, it did not contain a communicable disease exclusion. However, the issue there that they are apparently focused on right now, and again, I don't know how this is going to play out. We haven't heard of any coverage decisions being made yet, at least not that I'm aware of, is that they have a narrower definition of cancellation than the other policies have. And there they define cancellation as being physically or legally unable to hold the event. So under the HCC policy, they are likely going to take the position that unless you are banned from holding the event by some governmental agency, that it's not going to qualify for coverage under that policy. Again, I don't know how that's going to play out. I have a lot of arguments why there are other things that would make it physically impossible to hold the event, unable to hold the event, but we'll see how that plays out. Next slide, please. The first point I already talked about the showstoppers and the Expo Plus policy, about the kind of threat or fear of communicable disease exclusion, even if you bought the endorsement. There is, in the showstoppers and Expo Plus policy, the communicable disease exclusion that's in the core of the policy says that exclusion does not apply unless the disease has been declared an epidemic or pandemic by the World Health Organization or federal or local government agencies. That's a moot point now because it has been declared a pandemic, but prior to that, and in other situations prior to that occurring, in fact, in most situations, a lot of these things, the smaller outbreaks, are not declared a pandemic or epidemic. Then you have a strong argument that the exclusion does not apply at all. And then, again, this is a really important point, not necessarily for right now because no one's pretty much holding meetings and probably won't for the next few months, but after this plays out, and certainly before this point, that if you decide to still go ahead with a meeting, even in the light of some crisis that is, or some situation that's causing less attendees to come than normal, that these policies, all of them cover this concept of enforced reduced attendance, which means the enforced inability of participants to attend the event solely and directly as a result of the same specific cause, which is beyond their control and is not otherwise excluded. So if you decide to proceed with an event anyway and you have less attendance, these policies, if they apply, and as you can see, there's a lot of hoops to jump through, but if they apply, they'll make you whole. Next slide, please. Commercial general liability insurance. So this is if you decide, to proceed with an event. Again, not now, but you're rescheduling several months from now, August, September. There's still some risk out there. You go through all the precautions, everything the CDC says. I'm sure they'll have guidance out at that point once people start holding meetings again. You follow all of that guidance and then some. You do everything to show that you're creating the safest, healthiest environment for your attendees as possible. But someone still contracts the virus or gets quarantined or something, and they file a claim against you. Your commercial general liability insurance should step in to protect you and defend the claim, at least cover the legal fees. It's unclear whether these policies, and all the CGL policies are pretty much the same. It's unclear whether they would, how far they're going to extend their coverage obligation, but the short answer is there is no exclusion for communicable diseases. Conferences and events are the kinds of things, for slip and fall and other bodily injury and property damage that occurs at events. That's what CGL policies, one of the main things they're designed for. So it should provide coverage for you there. Again, who knows what sort of exclusions might be instituted in the future. Next slide, please. If you, whether it's holding an event and one of your employees gets sick, or you decide everyone's working from home these days, but, a few months from now, or however long, you reopen the office, and one of your employees contracts the virus at work or through a work-related event that you require them to go to or something like that. Again, there are no exclusions, thankfully, in at least the current form of workers' comp insurance for communicable diseases. So unless some other unrelated exclusion applied, you should have coverage for claims that arise under your workers' comp insurance policies. Next slide. I believe this is my last slide. And then I know we have a bunch of questions here. Future meeting contracts. And again, it's not too soon because not just renegotiating current ones for later in this year or next year, but just the usual cycle of meeting contracts. I think there's a general widely held assumption that by next year at a minimum, if not sooner, the meetings will be kind of back on schedule, the way that they have been in the past. And so the usual cycle of negotiating meeting contracts for next year, and we have contracts that are negotiated right now for some of our clients out to 2030 and whatnot. Some of these larger associations do them many years out. So as you're focusing on these future meeting contracts, there will be a very renewed focus on the force majeure provision. That will, I think, never again for the foreseeable future be one of the more overlooked provisions in meeting contracts. There's also no question that the venues, the hotels, convention centers, other venues are going to push back hard. This is going to be a really difficult negotiation. As I said earlier, try to tie the force majeure provision into the attrition clause, so that in the event that you do decide to hold a meeting anyway, even when there is a force majeure event, you decide we're going to go ahead anyway, at least you won't be penalized for reduced attendance. For purposes of that frustration of purpose common law claim, state the principal purpose of the event in the contract. It may help you support a frustration of purpose claim later. Again, it's not anything I would ever suggest leading with in your negotiations with a hotel or event venue, but it's something nice to have in your back pocket in the event that you end up litigating or arbitrating a claim. And then finally, who knows what the exclusions are going to look like in the future, but while you may not be able to get coverage for coronavirus for the foreseeable future in event cancellation policies, event cancellation insurance policies are still very important. There are a lot of other claims that can come up that can give rise to having to cancel or postpone or have reduced attendance at an event. And I strongly recommend, there's a lot of associations right now that one of them told me yesterday, yeah, we never really purchased it because we just thought there were too many exclusions. It wasn't worth it. But boy, do we wish we would have. I think a lot of people are saying that now. I particularly for the bigger meetings, particularly where it's a significant percentage of your annual revenue, I think it's a worthwhile investment. Focus on the definitions, the endorsements, and the exclusions. Next slide, and I believe it is time for questions now. And Wendy, as I told you earlier, for whatever reason, my screen is locked up, and so I'm not able to scroll through and read the questions. I see a few here, but why don't you just read some of the questions, and I will do my best to answer them in the next 15 minutes or so.
No
and
problem.
if you press F5 on your keyboard, you may be able to refresh the screen. Go ahead and try that too, Jeff.
No, that just brought up a video player. I did Control R. That might refresh it. Oh, here we go. Yep, could have done that the whole time. Okay, we're good. Let's go. Oh wow, we have a lot of questions. We have close to 100 questions here. Okay, let's see. There are legal questions around convening statutorily mandated annual meetings of nonprofits that have members. Yeah, it's a long question, but I've gotten this quite a bit, including from some clients in the past few weeks. So for those nonprofit organizations that have members with voting rights, and all nonprofit corporations, when you incorporate every state nonprofit corporation statute, makes you say whether you have voting members or not. If you have voting members, that triggers a whole bunch of things under the state statutes. And one of those things that virtually every state requires is that when you have voting members, that there be an annual meeting of those voting members. A lot of times that annual meeting will occur at your annual conference. For those, like most associations at least, that have an annual conference. Those annual conferences that are being canceled there's been a question, okay, how do we hold the annual meeting of the members that is statutorily required? In that situation, what most associations are doing is just simply holding the meeting virtually. Virtually everyone that I've ever looked at, which is most of the state nonprofit corporation statutes, allows members and boards actually to hold meetings virtually as long as everyone can hear each other. So like a Zoom meeting or an audio conference or whatnot, as long as everyone can participate. In addition, membership meetings, and this is in contrast to board meetings, this is not allowed for board members and board meetings, but for membership meetings, members can vote by proxy and they can participate by proxy. So someone can you can have an annual meeting just for the purpose of meeting that statutory requirement. All but one person, for instance, could give a proxy, and they could do it electronically by email or some other electronic system. And then you hold a meeting, those proxies count toward a quorum. You take whatever action is typically taken at that meeting, and it may really be none, just an update, and maybe some legal action. Obviously, in a lot of associations that have members, there's the election of board members and whatnot and officers that occurs at that annual meeting. But all of that can occur virtually, either through some actual live electronic meeting or through email ballot. So members, as opposed to board members, are allowed to vote by email ballot. This all has to be provided for in the bylaws, but assuming that it is, then you can satisfy the requirement that way. And frankly, that's what most organizations are doing. Are you willing to make comments about what particular companies, and what they're dealing with? No, I'm not going to talk about any particular brands and what they're doing, but I will. I got permission from my client, even though I'm not going to identify my client's name, but it's a fairly high-profile association. And this was a letter we got yesterday from the sales director of this particular property, part of one of the major hotel chains. I'm not going to say what one or what city, but the CEO of my client and others there and myself were pretty galled when we read this. Well, there's been a great deal, this is a quote from the letter, well, there's been a great deal of recent publicity regarding coronavirus. Currently, the situation is essentially no different than other health advisories issued by the CDC and the WHO. These organizations report on outbreaks of various types of influenza, West Nile virus, and even measles, all of which occur in the U.S. We will closely monitor coronavirus updates and respond based on the advice of governments, etc. However, generalized risk of communicable disease is a fact of life and therefore is not an unanticipated circumstance that will enable a party to invoke force majeure under current circumstances. I can't obviously hear any of you or see your reaction, but I'm sure you're as galled as I was late last night when I saw that. And needless to say that we're not going to stop there. But that was it's a more extreme example, but it's coming from one of the the brands, a major brand, one of the major biggest chains. And I'm just floored that this is the position that they still continue to take. Again, not the position for that everyone is taking. Every day that goes by, the hotels seem to be getting a little more flexible, but definitely not across the board, and they are really taking a hard line. What type of evidence do you need to exercise a reduced registration clause? I think sometimes, I know I talked about the meeting contracts, force majeure, cancellation without penalties. I talked about cancellation penalties and attrition penalties, and then separately I talked about event cancellation insurance. You may be conflating the two, because when I was talking about enforced reduced attendance, that's a concept that only exists in an event cancellation insurance policy. That concept doesn't exist in a hotel or convention center contract. What exists there is a concept of attrition. That if you have the meeting, but you have less people than you bargained for, with your minimums and whatnot, then you can be hit with those attrition penalties. So they're really two different things. And of course, like everything else, attrition penalties are negotiable. Cancellation penalties are negotiable. Everything's negotiable, and that's what we're spending a lot of time doing these days. And one of the best tools, levers, to successfully negotiate down those penalties, well, A, is if you have a really strong force majeure position, of course, but B, is your willingness to hold future meetings with that particular property. What advice would you recommend for nonprofits who are discouraged from purchasing event cancellation insurance out of fiscal responsibility. And the questioner says a lot of colleges and universities. I think this experience is going to cause a lot of people to think otherwise. Now, some have said, yeah, but if it was, based on fear or threat of attending, the companies are probably going to try to deny coverage anyway. Yes, that was happening 2 weeks ago. But now, with all of these governmental bans, and I keep seeing more and more every hour, and then the numbers keep getting lowered. We have, like Philadelphia had, I think, 1,000 people in place. That is almost certainly going to be lowered. We're seeing a lot with 250, now a lot going down to 50. We're going to see that more and more and more. Is hardball as common for entities with which the venues may have an ongoing relationship? That's a great question, because some of my clients have said, look, we've been working with this property for years. We have regular meetings there. I have one that literally holds their meeting there every single year. And they are just shocked at what a hard line the hotels are taking right here. How does force majeure relate to impossibility of performance? I've already talked about all that, so I'm not going to go back through that one. And by the way, if any of you, I can't promise I can get back to all of you, but you see my contact information on the current slide. And if you have a specific question that is not answered by what I covered here today, feel free to reach out to me by email, and I'll try to get back to you. Is a cancellation penalty different than a non-refundable deposit? Yes, it is very different. The cancellation penalties are generally spelled out in the contract in a whole cancellation clause. And again, those penalties generally go up the closer you get. It's kind of a sliding scale, and they go up the closer you get to the meeting. What those provisions often say is that if the hotel believes or convention center believes you owe a cancellation penalty and you had a deposit, that they have the right to keep that deposit and put it toward the cancellation penalties. But they are two different concepts. And I also talked about the role that the deposit plays in having leverage in those negotiations. The other thing we're seeing, and hopefully we'll see less of it, but in part of the hardball that we're seeing some of the hotels and convention centers play here, some of them are saying, okay, we're going to assess you the full amount of the cancellation penalties, but if you rebook, another similarly sized meeting with us in the next year or 2 years, we'll credit, I heard a bunch of these, 25% of the cancellation fee toward the amounts you would owe us under the new contract. Again, I'm hoping those positions become more flexible, but that's what we have heard quite a bit from a number of folks. We take a few more questions here, and then we're going to stop in a few minutes. Can you address what you're seeing around sponsorship agreements? That's a great question. And to be honest, I think our clients, at least all the ones that I've worked with over the last couple of weeks, have been so focused on the big contracts with the hotels, convention centers, and some of the big vendors that they haven't yet focused on things like sponsorships. And you also have agreements with exhibitors, with advertisers, with others. And I think a lot of this, it's a great question. I know I'm going to get involved in a lot of these things. If you cancel the meeting altogether, then obviously the sponsorship cannot occur. If a sponsor has not yet paid you, it's probably a moot point here, and there's really not much to worry about. If the sponsor has paid you or the exhibitor has paid you, and that's often the case, especially for meetings that are coming up, in the next couple months, either paid you all or some of it. This is a really difficult thing that a lot of associations are doing, which is trying to figure out, these are important relationships we have with our attendees, with our sponsors, with our exhibitors, and we don't want to burn bridges here, yet some of them are in a really difficult financial situation. So I see some that are just refunding the money to everyone. If they cancel, everyone is getting their money back, and they can afford it, and they have big reserves, and they can afford to do that. And I generally think that's the right approach if you're able to do that. You have the ability. If for the smaller ones that don't have big reserves or virtually no reserves, they're trying to come up with some ways to incentivize those individuals and companies, to kind of maybe roll those funds over to the next meeting, maybe give them some financial incentive and or other incentives to do so. Maybe give them a bigger booth for the same price, or a bigger sponsorship package for the same price, or things like that. But so the decisions on whether and when to hold the conference and those contracts with the hotels and convention centers, that has to come first. But then all of these ancillary agreements and relationships with other folks, including sponsors, are going to need to be figured out. This is a great question because I've seen this 3 times already with clients. What if the hotel has a credit card on file and just hits the credit card? Well, we had one that did that recently. The hotel, I believe, I can't remember the details. I believe we sent a force majeure cancellation notice, and there was a credit card on file from the association, and they hit it or tried to hit it for the full amount of the cancellation penalties. In one case, and I actually don't remember the details on that one, but in another one, the association actually went and they had a feeling this might happen. It was a very big meeting. They voided the card, reported it as a stolen or fraudulent and whatnot. Just had it canceled. The hotel went to charge the card. It was declined, and then the hotel actually reached out and said to the association, we lost the card that you gave us. Would you please give us a replacement card? And obviously the association was not going to do that. Because as I said, possession is 9/10 of the law. So who has the deposits, who has the money, makes a big impact on how these things get negotiated. What if a ban, such as an executive order by a governor or mayor, has an open-ended end date? This is the case in Maryland, at least. Yeah, this is critical. This is absolutely critical. Some of these bans are only in place for a defined period of time. I gave the example of D.C. earlier, which is one of the shortest. It's only in place through the end of March right now. Most are in place for longer. There's certainly an expectation that will grow. Like in Maryland, I read the order from Governor Hogan the other day, and his says that ban on the number of attendees will stay in place for as long as there's a state of emergency in the state of Maryland. That's ideal for an association that has a meeting in Maryland, say in May or early May or something like that. That's an ideal scenario. You can make, I think, a pretty compelling argument that right now that ban on meetings of, I forget the number in Maryland, if it's 250 or less, would apply to a meeting that's being held in early May, whereas if the ban only goes through the end of April right now, if your meeting is in mid-May, what we're advising most clients to do is to wait and see if and when that ban gets extended. But if it has an open-ended end date, I think you're in a much stronger position. It doesn't mean that the property is not going to push back and try to argue differently, but that's been our general recommendation. Just a couple more questions. You decide to go forward with the event virtually. These are great questions because we're seeing this a lot. With a substantial discount or even free to attendees who have already registered, how might you frame that to the venue in order to still avoid costs? So again, I think we're conflating 2 different issues. If you decide to hold, it's usually the educational portion of your event online because A, you still believe it's important to deliver the education. You have all these great speakers willing to speak. Most of them had PowerPoints anyway, so to do it virtually through online platforms is not difficult to do. A, you still deliver, you're still bringing value to your members and your attendees. You're still delivering value. But secondly, you can still charge for that. Now, like the questioner said, you might charge less. We have some smaller groups that are actually charging the same or hoping to be able to charge the same because they're so cash-strapped for the revenues that they're hoping that enables them to keep some or all of those revenues. But I don't think this has anything to do with the negotiations with the hotel or with the insurer. The facts and the analysis that I just spent the last hour talking about really have nothing to do with if you decide to go forward with a virtual version of your conference. Of course, if you're postponing as opposed to canceling, maybe that could have some impact on it as I think about it. But other than that, I think they're generally 2 separate issues, and the decision to pursue a conference virtually, it's just a separate issue, and it tends to be more of an economic one and a delivering value to your members one. As you noted, commercial general liability insurance may not exclude coverage for these claims, but the insurer may say there's insufficient proof as to where the virus was contracted. So this is exactly right. And if you remember, I was qualifying my words earlier when I talked about this, and even in my slides, I said you should have a duty to defend under the policy that because there's a bona fide claim that someone contracted the virus at your conference, there should be a duty to defend. But whether they would actually pay out the full amount of a claim is a very different analysis, and I think you're exactly right. It says no insurer will some clients insured said no insurer will likely pay such a claim. And I talked to a few insurance brokers that do a lot of work in the space, and they said the same thing. But frankly, as you guys all know, as lawyers, having a duty to defend and paying the legal fees and whatnot is critical in these situations. All right, let me take one more question. What should you do to recoup lost profits when the meeting venue cancels? I guess part of it depends on why. If the meeting venue cancels, like in Austin, as soon as Austin shut down large gatherings, the convention center reached out to our client and said we have to cancel, and they're canceling pursuant to the force majeure provision. So in that situation, they're canceling with the same, no liability that the associations would have on the other side. And so there's nothing you can do to recoup lost profits unless you had event cancellation insurance that applies. If it did apply, you probably would have coverage, almost without question, if you didn't have a coronavirus exclusion or a communicable disease exclusion. But in a situation like this, you're not going to be able to do anything to recoup lost profits. But A, you're not going to be stuck with any cancellation penalties, and B, hopefully you can negotiate, a new contract with them for a future year, and hopefully on more favorable terms. And most importantly, and this is my last point, and all of those future contracts pay extra close attention to the force majeure clause. It is about 2:20 Eastern time. I'm going to wrap this up now. Again, if you have some burning questions that I didn't answer, feel free to reach out. Otherwise, thank you very much for your participation today. Sorry for the technical glitch in the beginning. I accidentally had my phone on mute, and thank you very much.
Everyone, to our presenter for this program, Jeffrey Tannenbaum, thank you so much for sharing your expertise with us. On behalf of the ABA, thank you all again for joining us. Before leaving, wait for the evaluation to come up on your screen. Thank you. And on behalf of the American Bar Association and the ABA CLE, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at www.americanbar.org. Thank you, and please click on the evaluation link. We value your feedback. And for those of you who want CLE credit, please click on the link now appearing on the presentation window. This will open up the program evaluation. After you submit the evaluation, the attendance confirmation form and request for CLE credit will appear. Please complete the information requested on the form and submit. Your information will be verified, and if your attendance meets all the requirements for CLE credit, your certificate will be emailed to you.